Public servants have traditionally been treated as a special category under the law to protect them from frivolous, malicious, and vexatious prosecution. For instance, Section 197, Clause 1 of the Code of Criminal Procedure, 1973 sought to protect public servants accused of committing offences while acting or purporting to act in the discharge of their official duties. This protection prohibited courts from taking cognizance of such offences without previous sanction from the competent authority. The BNSS carries forward this protection in Section 218 Clause 1, which corresponds to Section 197 Clause 1 of the CRPC. However, the BNSS goes a step further by introducing additional safeguards for public servants. Section 223 Clause 2 of the BNSS is a new provision that grants extra protection to public servants at the pre-cognizance stage. Additionally, Section 175 Clause 4 of the BNSS confers certain additional privileges upon public servants. Section 223 Clause 2 of the BNSS prohibits a magistrate from taking cognizance of a complaint against a public servant for any offence alleged to have been committed in the course of discharging official functions or duties unless two conditions are met. First, the public servant must be given an opportunity to make assertions about the situation that led to the alleged incident. Second, a report containing facts and circumstances of the incident must be received from the officer superior to the public servant in question. A close examination of Section 223 Clause 2 reveals several key points. The provision applies only to complaints, not police reports. It specifically addresses offences allegedly committed by public servants in the course of discharging their official functions or duties. Before taking cognizance, the court must allow the public servant to present their version of events and obtain a report from their superior officer regarding the incident's facts and circumstances. It's important to note the distinctions between the bar under Section 223 Clause 2 of the BNSS and that under Section 197 Clause 1 of the CRPC. While both provisions aim to protect public servants, they operate at different stages of the legal process and have different requirements. The scope of the proceedings under Section 223 Clause 2 is similar to that of the first proviso to Section 223 Clause 1 of the BNSS, which mandates that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity to be heard. However, the requirement to obtain a report from the superior officer, as stipulated in Subclause B of Section 223 Clause 2, raises questions about its feasibility and effectiveness. The purpose of obtaining such a report appears to be to help the court determine whether the alleged act was indeed committed in the course of the public servant's official duties. However, this approach has potential limitations. Often the superior officer may not have witnessed the incident or have direct knowledge of the transaction in question. In such cases, their report may not serve any useful purpose. Moreover, the decision to take cognizance of an offence should primarily rest upon the contents of the complaint rather than a report submitted by a third party regarding the alleged incident or transaction. This raises concerns about the necessity and effectiveness of this new provision. In conclusion, while Section 218 Clause 1 of the BNSS already provides substantial protection to public servants from malicious and vexatious prosecution, the introduction of Section 223 Clause 2 seems to grant additional, potentially unnecessary protection. The existing safeguards, including the right under the first proviso to Section 223 Clause 1 of the BNSS, already ensure adequate protection for public servants. The effectiveness of a report obtained from a superior officer in influencing the magistrate's decision to take cognizance is questionable. Ultimately, the decision must be made by the magistrate after judicial application of mind to the contents of the complaint. While the BNSS aims to strengthen protections for public servants, the practical utility and necessity of Section 223 Clause 2 remain debatable. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.